Good morning, everybody. Welcome to another episode of Monday Morning with Mo. I am Attorney Mo DeWitt, and here to answer all your legal questions, just like we do every morning, or Monday morning rather, at 8 a.m. here on Facebook, YouTube, and wherever else we can put this thing. So thank you for joining us once again. Some great weather out there this morning, or cooler weather. I won't say great weather, but cooler weather. Already got my morning walk in, so we are ready to go. Just a reminder, we talked about the Fun Spot party last week. It's going to be Sunday, December 6th at Fun Spot Orlando. If you haven't been there before, they got roller coasters and go-karts and all sorts of fun stuff. Absolutely free for you and the family. You just have to register in advance at justcallmo.eventbrite.com. Space is filling up pretty quickly, so go ahead and register if you want to come out. Should be a great time, though, so hope to see everybody there. And let's go ahead and get to our legal questions this week. So we got quite a few emails, a couple voicemails. So question one, I'll leave this one anonymous because it is a little bit sensitive. So he says, hello, I'm a father of two children. My ex-girlfriend is the mother of both. My ex currently has a felony child abuse charge against her. She was arrested and bonded out yesterday. Her bond was modified, so now she has full contact with the kids. I spoke to the state attorney's office. They requested the case info and will determine if there is enough evidence to get a conviction. My question is, should I file for paternity now with not knowing if the state will take the case, or do I wait until I know for certain that there is enough to get a conviction? Well, in this case, the child abuse charges, while relevant, don't really necessarily impact whether you should file for paternity or not. If you were never married in Florida and you have children with a woman, the father technically has no rights until there's an adjudication that you're the father. So basically, you have to file a paternity action in court that adjudicates you as the father, that makes a finding, a legal finding, that you are the father. And then from there, then you get time sharing established, or custody as it's commonly called, and they establish child support as well. So at this point, whether they proceed with the child abuse charges or not, you really need to go ahead and start that paternity action, in my opinion, as soon as possible, so that you do have legal rights to the children. Because otherwise, you really aren't a party as far as the state's concerned. Until there's an adjudication that you are the legal father, you're really not involved. Now, they could place the children with you in your temporary custody if they believe that that's in their best interest, but they could also do that with a complete stranger. So you want to go ahead and get that paternity action filed right away. I don't think there's really any reason to wait. There's some judges in Orange County, at least, that used to say that if you weren't married, you should be filing the paternity action either the day the child's born or even sometimes prior to the child being born. So I would definitely recommend doing that. I'm sorry your kids are going through this. It sounds like an awful situation. But for your purposes, to establish your legal rights so that you can do what's in the best interest of the children, I really think you should go ahead and file that paternity action. So great question there. We get that one a lot as far as the paternity action goes. I don't think a lot of people realize that, unless there's an adjudication that you're the father, that you really have no legal rights. So something to be aware of. So let's see. Let's go to a voicemail next. So let's see what we got here.
Hi, I'm calling because I heard something on the radio about recording. Some gentleman talked about another issue he had, and he talked about recording. And my question is, before I got married, I had a prenup agreement done, and what I would like to know is if I need to have that recorded with the county. Thank you.
So the question is, do you need to record a prenup, basically? If you have a prenuptial agreement, it doesn't need to be recorded with the county or filed with the county. Short answer is no. No, prenup doesn't need to be recorded at all. But I have had cases before where people enter into a prenuptial agreement or a postnuptial agreement and they lose it. And so that creates an issue, obviously, if you go get divorced and you say, hey, they both agree, hey, we had the agreement, but neither one of us have the copy. So typically what I recommend is, if an attorney drafted it, ask them to keep a copy on file, maybe just a digital copy even, a signed version, not an unsigned, a signed version. And then take the original and put it in a safety deposit box. Put it somewhere that you can just kind of forget about, but it's not going to get lost. Because if you don't have the agreement, then it doesn't do you any good. You spend all that time and money drafting it, but at the end of the day, you don't have it. I'm not aware of any procedure to really file it with the county. It certainly doesn't have to be recorded. Typically, a prenuptial agreement or even a postnuptial agreement is really just a contract between you and your spouse. So it wouldn't be recorded, but you do want to make sure you keep that in a safe place so that you don't lose it, because otherwise it's no good to anybody. All right. Let's go to our next email question here. Again, I'll leave this one anonymous because it's also a little sensitive. My ex started an abusive verbal agreement. She called the police, and I hit him. The cops didn't buy it, but I admitted to pushing him like an idiot, so they had to arrest me. She put an order of protection out, so I can't go home or see my kids until a hearing is held. What should I do now? All right, so an order of protection is what we refer to as an injunction, a domestic violence injunction. So if there's an allegation of domestic violence, in this situation someone was arrested because they admitted to the pushing, I guess, an injunction goes into place, which basically means that you can't go to the other party's residence or within 500 feet of that residence while the injunction's in place. And the way an injunction works is if you go to the courthouse, you can file an injunction. And basically whatever you put in that petition for the injunction, the court has to take as true. So if they find the allegations that are listed sufficient, they go ahead and issue a temporary injunction, which basically says the individual who the injunction is against cannot go within 500 feet of the person who's being protected, or typically the person's home or work, until a hearing's held. So usually they have to have a hearing kind of an expedited basis. It'll usually happen within about 2 weeks. But until then, you're kind of left in limbo because you can't go back to the house, and sometimes you may have lived there. It may have been your home. But you can't go back there until a hearing is held. That can sometimes, as in this case, get a little complicated when there's kids. So sometimes you may be able to motion the court to modify the injunction to allow you to see your kids in the interim. But it may be difficult to get a hearing time on that, to get in front of the court to have that heard within that shortened period. So basically, let me back up. They have to accept everything as true. If they find the allegation sufficient, they issue the temporary injunction. But then after that, that's when you get an opportunity to be heard, and that's when there's a hearing. And you have to have a hearing because of due process. Both parties have to have an opportunity to be heard. And so there, at that hearing, then you can rebut whatever was said if it's not true, or if the allegations are exaggerated or don't, meet the criteria for an injunction. That hearing is your opportunity to ask the court to deny the injunction. If they deny it, the injunction is lifted, everything goes back to normal. If they grant it, then the injunction could be issued for a period of time. It could be a year, it could be 5 years, it could be 10 years, depending on how severe the allegations are. So it's pretty serious to deal with. You want to make sure that you probably hire an attorney for this to properly represent you, because they can get pretty nasty. So sorry you're going through that. Moral of the story is, probably never give a statement to the police without an attorney present. You don't have to, so I wouldn't admit to anything if that ever happened again. But just my 2 cents there. So, anyways, best of luck, and let's go back to the old voicemail lines here. See what we got left over here.
Hi there, my name is Kim, and I have an established trust, and have funded that trust with my assets, but I do not have a beneficiary that I feel I can have to administer the trust after I pass. My daughter is in a relationship that I do not know that will survive. So I want to have this money for my grandchildren. What are my options besides family and friends for a beneficiary, for a trustee? Not a beneficiary, but a trustee.
All right, great question. So a trustee can really be anybody, frankly. There's professional trustees. Banks often offer a professional trustee service. It could be a friend, a family, a relative. It can really almost be anyone that you would like to be the trustee. And in this case, if there's no friend or family member that you trust, you can appoint a professional trustee. They do get paid a fee for their work typically. But banks and other entities do offer that service. So you can simply appoint a professional if you no longer want your your daughter to act as the trustee. Just, I would probably contact whoever wrote the will and the trust, see if they have anyone they recommend, and then go from there and go ahead and modify that provision in the will and the trust. So pretty straightforward there. We got one more legal question to get to. So our final question of the day is from Sean. So Sean says, I was at work and I was lifting a heavy bag, and as I did, I felt a crack in my wrist. That doesn't sound good. I had a bad sprain in my wrist, but the pain goes to my shoulder. Do I have a case of any kind, or is there anything I can do to get compensation? All right, Sean. So anytime that you are injured at work, you could potentially have a workers' comp claim. And I'm not talking a little scratch. I'm talking about if there was a serious injury that you need medical attention for, you could potentially have a workers' compensation claim. So I always recommend calling an attorney if you are injured at work. And remember, with workers' comp, it's not a negligence standard. So the company doesn't have to be negligent in the situation. It's just a matter of you were on the job and you got injured. So I recommend give an attorney a call, see what your rights are, see if you have a case, see if it's worth bringing a workers' comp claim. But you want to make sure that you do that right away, because workers' comp does have a limited statute of limitations. So you want to make sure the claim is set up right away and that you move that as soon as possible. So great question there, Sean. Certainly appreciate it. But yeah, I would give an attorney a call, a workers' comp attorney. Talk to them. They can find out what kind of treatment you've gone through, if there's a claim, and what your best route there is. So anyways, that is all the questions that we have for this Monday morning. If you're still watching this, I certainly appreciate it. Hope you're enjoying it. Again, December 6th, Sunday, December 6th. Make sure you register for that Fun Spot party. We're going to have, should be a great time. We'll have a lot of freebies, merchandise, all sorts of stuff to kind of hand out there. So hope you guys can join us. Just make sure you go to justcallmo.eventbrite.com. And at the end, I'll post something in the comments with a link as well. So that's there for you guys to click. So otherwise, have a great Monday. And I will see you guys next Monday morning at 8 a.m. Take care, everybody.